Welcome to Salu Law Channel. My name is Femi Salu. I am an attorney and I specialize in personal injury cases. I've been practicing law for over 20 years and I'm licensed in Mississippi and Tennessee. I am persuaded to start this episode by the numerous questions and calls I get over the years from thousands of people who are injured or have one form of legal questions to ask lawyers. And it's my interest to start this episodes. This will be the first episode, just to provide the basic information. Now, don't get me wrong, I am not your lawyer. What I'm providing here is the basic information for you to be able to go to your lawyer and seek proper legal advice. And the first episode we'll be talking today is how long does a personal injury lawsuit take? That is a question I get fairly regularly. Before I answer that, I need to let you know what happens when you make a decision to file a lawsuit. It is possible that the insurance company has been lowballing you or your lawyer. You hire an attorney, you sign a contract, what we call, in personal injury cases, most of the contract we sign with the attorney is what we call contingency fee agreement. It is where the lawyer charges a certain percentage for representing you as his attorney's fees. If he wins the case, then it takes as his attorney's fees that percentage. If he loses, it takes nothing. In most of the personal injury cases, the lawyers will fund the expense of the lawsuit, but he will deduct those expenses at the end when you receive settlement, final settlement in the case. But there are instances where the lawyers feel, look, I'm not so crazy about your case. You have to fund the expenses. I'm not going to charge you attorney's fees, but you fund your expenses. And I will not charge you upfront for attorney's fees. I'll take a percentage of what your settlement will be. In such cases, maybe the lawyer is not impressed about your case, he's not so sure about it, and he feels both sides should bear the risk of filing a lawsuit. Now, let's now go forward. You and your attorney have decided that you want to file a lawsuit. What do? The first thing the attorney does is to prepare a complaint. A complaint is just a statement of facts of you, your name, where you live, the issue of jurisdiction, that is, where you are bringing your lawsuit in Tennessee, whether it's in Shelby County, in Mississippi, whether you are bringing it in DeSoto County, and all that. Your attorney knows a lot about that. He will put that in the complaint, and then he will recite how the accident happened, and then conclude it by talking about what you have been through, your pain, and all that. And he will conclude it by asking for the damages, that is, how much he wants to settle on this case. Now, your attorney can ask for $1 million. That doesn't mean he's going to get it. The insurance company might come back and ask and offer $500. So don't be misled too much by the amount the attorney is asking for. Now, that is always like the first offer. If he files the lawsuit, I want you to remember one thing. It takes an average of 1-2 weeks for him to serve a summons, which has to be issued along with the complaint on the defendant. Let's say the defendant is in Memphis, somewhere. You'll have to get a process server. You'll have to get or someone from the sheriff department to serve that process, the papers from the lawsuit, this lawsuit complaint and summons on the defendant. The defendant is the person that caused the accident. Then that is the first 2 weeks. It might take a month. If your defendant is avoiding service, it might take more than a month. It might take 2 months. But in most cases, within 2 weeks, where, for example, you are suing a company or a defendant that has a reliable place of location and address, is normally served within 2 weeks. After it is served, the process is served, the defendant, that is the person that caused your accident, will have 30 days, that is 1 month, that is in both Mississippi and Tennessee, to respond to your complaint. Most likely, and in almost all cases, what they do is get an insurance company the insurance company will come in, hire an attorney for the defendant, and in that case, what you see is they will file what is called an answer to the complaint. I want you to remember this. They have 30 days to respond to those complaints, to the complaint that you have. 30 days. So you have now almost a month and a half. Thereafter, you now go to a stage where you call discovery. That is when your lawyer will have a set of written questions and a demand in terms of documents to be produced. Your lawyer will send it to the defendant's attorney. The attorney also will send those written questions. They are called interrogatories and requests for production of documents. Sometimes there might be a request for admissions. That is, they're asking you to admit certain things now. Your lawyer will remember that and promptly answer that, because if he fails to answer a request for admissions within a specific number of days, mostly 30 days, he's deemed to have been admitted. So most lawyers don't take that, they take it serious, request for admission. But you have these questions that you have to answer, and they have these questions that they have to answer. When written questions are completed, you now go to the next stage, which is deposition. Now, all these interrogatories, requests for production of documents, requests for admissions, that is typically, it takes another 60 days. It might even take 90 days. Once that is done, you go to the next stage, which is deposition. Deposition is where you will sit down in a conference room, either in your lawyer's conference room or the opposing lawyer's conference room, and there will be a court reporter. The judge will not be present. The court reporter will be the one to be taking down everything you are saying. The other lawyer will be asking you questions as to how the accident happened and all that. And at the end of that deposition, the court reporter will type it and send the transcripts to you for your lawyer to review. That can be used against you if you say something that doesn't support your case. Expect the defendant's lawyer to file a motion for summary judgment. What that means is they might file a motion that your case be dismissed. That is, your case is not going to the jury. That's what it means. Your case is not going to go to the jury. They might file a motion to dismiss your case. The same thing can happen with you, your lawyer, after asking questions in a deposition on the other side. He might feel that he has a sufficient case to file a motion for damages. For judgment on the issue of liability. That is, you are no longer contesting the issue of liability. Your lawyer will file a motion that the defendant, the evidence support the fact that the defendant has admitted liability, so that the only thing we have to now discuss will be the issue of damages. And in some cases, some of the defendants might even say, look, we are not contesting liability. We are not contesting the fact that you were involved in an accident. We are not contesting the fact that our client is at fault. What we are saying is your injuries, you've been previously injured, and those injuries are a major cause of the present injuries you are responsible. So in that case, it comes to what your medical record says and what your doctors have to say. If your doctor says your injuries are more than 50% caused by the accident, then, but if he says it's less, all of that will feature in how much your case will be evaluated by the. From what I'm saying, we can speed it up within 6 months. That is pretty fast. It could be 9 months. It could be 1 year. But one good thing that I can tell you is that many lawyers don't want cases to linger in a court of law. And in the case of Federal High Court, if your case is filed at the U.S. District Court, what happened is that there is a scheduling order which says you have to do this within a certain specific period of time. And in that case, it moves pretty fast. So an average case, to answer that question, takes like 1 year before you can get reach settlement. In some cases, you might file a lawsuit, and that has happened. The other side might say, look, Mr. Salu, as they will say to me, please submit a settlement, a demand settlement. After looking at what you are complaining in the lawsuit, the other side might feel, look, we don't want to litigate this case. It's just too much against us. Submit a demand settlement. So in such cases, within 6 months, you find that the case is settled. So that answers how long a personal injury lawsuit take. Now, I do not want you to take what I'm saying here as the gospel truth, because it might take longer, especially in medical malpractice cases, in nursing home abuse cases. It might take 2 years, 3 years. I've seen cases taking 4 years, 5 years. It depends. If the parties are not willing to, if the defendant is not ready to offer settlement, it goes through motion, especially product liability cases. It goes through motions, and your lawyer will have to answer those motions. When you are confronted with such case, especially where the amount you are demanding is high, if you are asking for 7 figures, 8 figures, then they are going to play it. Even while the lawsuit is pending, don't forget that you might have a situation where an appeal is taken from any decision that goes against the defendant if they are not ready to pay you such an amount of money. I'll give you an example. I remember that I filed a small claims court case for a food poison at a pizza store on behalf of a client. In Mississippi, the jurisdiction is $3,500 on the small claims. In Tennessee, at the General Sessions Court, is $25,000. We got judgment in Mississippi for $3,500 against a family of 4 for eating poisoned food. That is $3,500 times 4 of them. The insurance company was not happy. They removed that case to federal court and secured it with a bank guarantee of $1 million, meaning they really want to fight us. We just have to settle that case at the end of the day, So I'm just letting you know to show that it depends on how your insurance company takes your case. Typically, it takes 6 months to 1 year for the average case, but it might take longer. So, if you have additional questions, call us. My main number, I have 662-342-7007. That number, I also have a Tennessee Memphis number, which you will see at the bottom of the screen. But the most reliable way of getting in touch with me is by email. It is Salu, SALU, at salulawfirm.com. Or you can go to our website, www.salulawfirm.com, where you can fill in whatever problem you are having in the contact page and get in touch with us. Please, this is our first episode. You're going to get so many episodes. I want you to share. I want you to subscribe and share this with your friends and families, and look forward to the next episode. So if you have any questions, call us back. Thank you.